All right. Welcome to the Immigration Podcast. And my name is Rob Ratliff. I'm an immigration attorney and former immigration judge based in Cleveland, Ohio. And our co hosts today are.
Annis, why don't you go first?
I'm Anas Sala. I'm an immigration attorney that's based out of Syracuse, New York, but I've worked all over, including internationally, in U.S. based immigration law. And I've had a great opportunity to work with Rob, even, and other practitioners, and do a full spectrum of immigration from the beginning to litigation. So, really honored to be on with such two great professionals.
Oh, you're so sweet. My name's Susan Hiller, and I am an immigration attorney, but I also, if you haven't caught our podcast yet, previously worked with the government for over 26 years. Actually, 30 years if you count my law clerk days, which is going to come up today because I have one of my cases is going to expand on that. But yeah, 26 years with the Department of Homeland Security and teaching also at the Federal Law Enforcement Training Center, which I'm going to bring up today because I think it's interesting, the whole term seeking admission, because I taught it for a long time.
Yeah, that was quite the topic of conversation at the Supreme Court hearing the other day. Did you guys, or not the Supreme Court hearing, but uh, there's a couple federal court cases on that issue and the entry and what is eligible for bond and not, and very heavily litigated now.
Well, what I don't understand, can I start on that real quick?
Yeah, because I would like your insight as to what the rule has been for the last 20, almost 30 years since
Yes, actually,
1996.
I wrote a habeas on it recently, and so it's been 30 years since it was legislated.
Yeah.
And it was the 104th Congress, and I'm going to age myself here because I worked for 26 Federal Plaza and when I was in law school at Seton Hall University, when IRA was being drafted, well, DEPA, and then it became IRA, and then I worked at 26 Federal Plaza as an attorney. I was a law clerk there during law school. I also then was an attorney, and it was the 104th Congress was, you guys, Annis, I don't know, you're a lot younger, but that was, I think, Newt Gingrich's Congress, and it was Bill Clinton, and at that point he had a very Republican Congress, and they passed that. And when they developed the term seeking admission, they told all of us, the attorneys, what the term meant, and the officers and the agents, and it was to be used in conjunction with expedited removal, which was to be done at the port of entries. That's all it was supposed to be used for, is at the port of entries. You were seeking admission if you were at the port of entry or the border, something that was considered, like a seaport within the port of entry or border of the United States. So it was 30 years ago. Yeah.
Yeah. And that's been the way that has been implemented since that time.
That's what I want to tell you all is when I taught, and that's the reason I'm wearing my old shirt here, immigration officer, because attorneys, by the way, assistant chief counsels are immigration officers. And no, I'm not proud of ICE at this moment, but they used to, they had better days. Let's put it that way.
Yeah.
Better days. But when you go back to the books that you guys can all FOIA, Freedom of Information Act, and these books are available for all of you because they are archived. But because let's think about if you have to actually sue an officer about his training. Those books, when I worked at FLETC, the Federal Law Enforcement Training Center, we had to keep them archived because there would be lawsuits against officers or the agency. So we had to show how we trained that particular officer at that particular time. So all of those books are available for FOIA, where you can see how we trained the officers for over 30 years on the term seeking admission. And I'm positive that it didn't change at least until 2020. If it changed, it would have been in 2025 under this administration, not under Biden. So, but the book should all say for the last 29 years what the term seeking admission is, which is at the port of entry.
Well, and that's the interesting thing, because there has been no statutory change. It's the only change has really been an administration's interpretation of a 30-year-old statute. That's what's changed. And, so far, we've got 2 circuit courts that are buying into it,
What happened to the Eighth Circuit? Why did that happen?
The opinion was very, it followed the Fifth Circuit's ruling, and it did talk about, and one of the things that that I've always thought has been somewhat inconsistent in that statute was the disparate treatment of those who came to the border and said, "Hey, I need asylum. I'd like to be in," versus those that went around the border, and that's always bothered me, the way that statute was read and adopted. I mean, if anybody should not be subject to mandatory detention, it's the person that comes and knocks on the door and says, "Please, can I come in?" From my opinion, both the Fifth and the Eighth Circuit is really just kind of focused on that old discrepancy, and has used that as kind of the starting point for their discussions as to why it should never have been interpreted that way previously. So now everybody is subject to mandatory detention, and which
Janice, what are your
makes
thoughts?
sense in my opinion.
My thoughts is I argued this back in 2018, and then it came back. When the Supreme Court came out with the Jennings decision, and it said the 230, the 230B it's mandatory detention. The only release that's available after mandatory detention is a parole. Okay, so I think that it stems a little bit from there. Now they're trying to play around with seeking admission or whatnot, because they obviously want to expand the mandatory detention thing. But what's just really interesting is, legally, have you paroled all these people, under matter of vote or whatnot? And I know, Rob, we've had discussions before about the new marriage residency is, people being paroled. If you're Cuban or if you're USC or, USC spouse or so on, that's pretty big. And I think that the rush to really go hard on mandatory detention and go to those limits to try to apply it as most people possible is kind of had that unintended effect of this parole issue. But here's a real problem that we think of. All these detentions that are out there, now they'll just detain someone. I had somebody that denied OAS. They pick him up. He's an overstay, right? And they're treating it like an expedited removal in detention. And look, sometimes they just want to go home or different things. Let's be honest here. Even I had a case where I was 100% right on everything that they did wrong, and they still deported them. It's like, what's the recourse there? Nobody's going to, apply to come back. And because even if he came back, it might not have the status or so on. So I guess the big concern is, all the arguments that we think about and all the legal things we talk about, at the end of the day, what is our recourse to actually present them in a way that it would actually make a difference? Sure, you could have a bunch of, the habeases or so on, but sometimes do you feel like you have those cases, they're stuck in detention, and they just don't listen to you, and there's no way to get it in? Because if you get an expedited removal, how are you going to get back into court? It's a lot of federal case.
Well, and that was a problem with even the habeases. You prevail in the habeas, and you get the federal court to order a bond hearing, but then you walk into the bond hearing, and the judge is now applying standards that have never been applied before, using entry without inspection. I have a kid, he's 21, detained right now because the judge determined that his entry without inspection made him a flight risk. He was 1. He was 1 when he was brought into the United States.
I had that same problem, and I had a kid. And when I argued about it, I actually told the judge. The judge said, "Well, he entered without inspection on a fake passport." I said, "Respectfully, Your Honor, if he had not entered without inspection, we wouldn't be having this bond hearing." So the fact that we can have a bond hearing means every single person that you ever granted bond to or denied bond to had an immigration issue. So we cannot treat it as just that one, because if he didn't have it, then we wouldn't be here. There'd be no purpose of a bond hearing. But as you see, if you even look at the most recent BIA decisions that are coming out, they're pretty
Oh,
interesting.
they're all against the respondent.
Yeah, they're against the response. Extreme use of a hardship. Now you got to have like a medical professional, or if the evidence could have been available. Think about
Yeah.
that. Like in the respondent's testimony, it's him or herself is not enough. Like who would know themselves better than themselves? So it looks like we're getting to that point where it's like, okay, like what are these new strategies we got to do? Because even if we're 100% right on the law, it's like, okay, like where does it go? You brief it, the law's right. It's almost like, so what?
Well, let me tell you about. Can I tell you, Rob, real quick, about a bond that was right on point what you're talking about?
Yeah.
Because it's frustrated me since last Friday. So it's in Folkestone County Jail, which is under Atlanta, and the judge is Jennifer Bell, and a new trial attorney. I forgot his name, but young guy. And I thought, we lost Annis. And are y'all there?
I'm here.
Okay. So,
1 second, I just lost my camera. I'll be right back.
okay.
We know you're there and listening.
Yeah, we know you're there. So, going back to this one. So this individual that I entered my appearance on, he came on a B2 visitor for pleasure visa at age 15 years old. He's been in the United States 23 years. He goes to an asylum hearing. I'm assuming somebody, I picked up this case now. I don't know what his history was before. Why did he put him for asylum after so many years being here? But let's just leave it at that. He put him for asylum. He's at his asylum hearing in 2025, and he's just about finished with it, and ICE shows up to pick him up. He put on the asylum application that he came in. This is a statement against interest. He wouldn't have known either that this would be something that could actually help or hurt him, right? It's actually kind of hurtful when you use a photo sub passport. But at 15 years old, he used a photo sub passport to come into the United States. He was trafficked in from India under the name blah, blah, blah. I won't say it right now because just not sure I should say it. But in any event, he came in under a certain name, and there was a girl that was trafficked with him. He said she was probably around his age. They were actually forced to go into a closet, a room, I should say, together, or a closet, he said, and memorize. They were locked in there to memorize the details of the passport way back then. So, I knew the whole iwi thing is going to be problematic for the bond hearing, right? Because they're going to claim Maldonado doesn't apply. I wasn't sure with Georgia how Georgia would respond, but that. Of course, they said that with Maldonado. But I said, Your Honor, with all due respect, he came in under a B2 visa, and the burden is on the government to prove time, place, and manner of entry. The burden is not on the respondent. And he's been pro se. He did have Margaret Wan's office for a short little period, just at the initial bond hearing. We back up to October of last year or September of last year. His third U.S. citizen's child was born. When he was detained, the child was 6 months old. So his first son, he's missed his child walking.
So
Yeah.
sorry. Did you say he entered on a fake passport? Is that what it was?
Oh, no, it's a real passport, photo subbed.
Photo sub. And what was the passport of the U.S. citizen passport?
Indian. No, not U.S. Indian.
And did he enter like a long time ago? When was it like?
Yeah, March 2003.
So you think he's one of those transit visa?
No, he
Entries?
came on a B2. Came on a B2. He was inspected and admitted. So if he had presented a false U.S. passport, if he had presented a U.S. passport, then he'd be evading inspection or admission.
Now, did they when on the NTA? Did he get NTA'd?
He did get NTA, but the government being the government in 2025, October 2025 or September, a lot of the good officers and agents had already retired, and whoever put him into proceedings, whoever issued the I-213, not only did they lie on the I-213 about his criminal history, and tried to act like he was some big criminal. I'll tell you, you did have 2 arrests, but it's not going to be what you think. It's what they put on there is completely to make him look like a very dangerous criminal, and it's not anything he was ever arrested for. So what I'm trying to say is, I don't know if the officers or agents had any training. They could have had only 47 days of
What
training.
the removability? What were their removability charges? Was it
Put
with
Iwi, put Iwi because they claim they couldn't find it, but they didn't try to find it. And that's where I'm going to go back to my 1992 being a law clerk at Boston College for INS, where I became an expert in this system called the Central Index System. It's an old DOS system.
Wait, to try to find the visa?
Well, I could find that in a heartbeat if I had
What
access
the
to
problem
it.
you have is, okay, you find the visa, they do an I-261, and they just change it to an overstay, right?
I don't care about that. He gets his bond hearing.
This is bond hearing.
He's got a cancellation. He's cancellation eligible. He's got to cancel. I mean, I'm not saying that that's the best route, but
Yeah.
he's because I don't know what I don't know. I have to look at the exceptional, extremely unusual hardship. They're creating it right now because the high school stepdaughter, although she doesn't qualify, that's the only problem. Because he didn't marry the mother. She's not married to the mother, but even if he married her now, they didn't marry in time. But the stepdaughter, who considers him the father, like her father figure, had to drop out of high school senior year this year to take care of her baby brother, who's 12 months old, because the mom has to work. And she was an A student, and she's missing her senior year in high school. That's going to affects her timeline in life. I mean, I could go through how it affects her, not just
But you said
mentally
he
and
was
emotionally.
trafficked? Did you say something about traffic?
Well, I'm going to file the T visa for him. He already put in a T visa pro se. He didn't do it right. He threw it into the court, and some inmate filled it out for him and didn't even only put really his name and address.
But now he's detained, so USCIS has already said, that in any of these kind of pending applications, they're not gonna do biometrics.
Yeah.
I'm gonna. There's gonna be a lawsuit on that. He's gonna get out soon. I've got a habeas about to go in. I actually have an organization that thank God is filing it for me and my client. That's going to help out because it's a lot to juggle. And they said they're winning in that area. They're just going to do it as an EWI, even though he is a B2 overstay. That way it's just easier. So
Yeah,
once he gets out, I'll be able to get him biometric. I'm not worried about that. But what I wanted you guys to note a few things on
sorry,
this.
but if are they gonna admit to him being an Iwi when he's not an Iwi?
Well, that's the thing I wanted to tell you
So if we
is
got
he did
material
not.
misrep, they could just cut it the other way. Say that you lied. Said the material misrep. You said
No,
that
he's
you're
not.
Iwi.
No,
In the
no,
habeas,
no.
in a verified habeas, yeah.
Yeah, you're throwing in
Wait,
perjury.
wait a minute.
So,
In the habeas, go back to that real quick. Go back to that thing. He's not admitting to that. No way.
you can't admit to
That's just
anything
the way that
They got to word it right. They got to word it that DHS says he's an iwi.
I'll make
Yeah.
sure. I'm speaking to that attorney who's been around for a long time, who's doing it
Yeah. He just doesn't want to stipulate to being an
on
iwi.
Monday, and I'll make sure that they know that this is how he says he entered. Either way, he gets it. Like if he entered the way he says, or if he entered the way DHS says. So what they're going to argue is that even if he is an iwi, like DHS says.
Yeah.
He doesn't have no
Because,
passport, no nothing. In what country? He didn't have no passport, no
well,
stamp.
it's 23 years ago. So he was brought in with, Indian smugglers used two adults that he had no idea who they were, brought in two different children. I don't even know what happened to the
But they
girl.
came in on the B2 visa. Shouldn't they come through the port of entry?
Yeah, Chicago O'Hare.
So they
March.
came.
I can find that record if the government gave me access to the central index system. I know I
The
can
problem is
literally
now a lot of
do
that stuff might be
search.
because of COVID stuff. I think they kind of got rid of it. It's a central
Nope.
repository, isn't it? They still
No.
got it.
Let me tell you something. So not only because I just I
But he has no
retired
record of it. He has no people he traveled
recently.
with. Nothing.
Wait. Honest, I want to tell you a few things
Yeah.
from the inside part.
Sure. Thank you.
So central index system, old DOS system, still around. In fact, they call it CIS2 now, but it's the same thing. Still same search numbers. I won't say them on here, but I know the search numbers, blah blah blah, their numbers and stuff. The search criteria. Whoever searched probably went under exact search, which is stupid. Okay, that's like going on to Ancestry. You don't really know everything about your ancestors. You go under exact. You may not find your ancestors. So what you do, and again, this is very similar to us in Westlaw stuff. Sometimes you got to play around and become really good at it. So with Central Index System (CIS), now non-immigration information system went away. I don't know why. I think I know why now. I didn't know why back then. They got rid of it after September 11th. I think because I found Muhammad Atta on there, and they kind of got rid of that. And I saw he trained in Air Force Base, but that's another show for another day. And that was September 12th, 2001. I saw that. Yes.
Susan, I'm
And I
sorry.
swear.
Susan, I'm sorry. I understand about the reciprocity because what I've been doing with my clients, especially ones that came older and they're from India, is I ask them, okay, what airplane do you remember boarding on? And they'll say like, oh, I remember. I forgot. I don't know if it was Pan Am at the time, but they said they remembered a certain logo. I said, okay, then where do you remember going? They said, well, we remember we stopped in Jordan. So I'm putting those together, India, Jordan. Then they said they went to Amsterdam. Then they said they went to JFK. Then what I did was I recreated and I found the actual routes with the logbooks to show that that flight was available at the time that they claimed the entry. Because what happens is if I'm from India, okay, India back in these times, 2000, 1993, it's not like now they could have crossed this journey. Okay, it's either they fly to Mexico or whatever. But back then it was hard because there weren't those routes to Mexico. So you could put it back together through the actual logs and you could prove that the flights existed. So sometimes what you want to do is, of course, we always want to believe our clients, but we got to verify. So if he's saying he came in on a B2 visa in 2003 as an Indian national, first, what we're thinking is at that time, it might have been during the whole transit time. Also, it was after September 11th. Might have been hard to get a visa as an Indian national B2. Okay, but he said he did it. So he said he flew into O'Hare. I think the
No,
next
he's
question.
using someone else's passport. I have a feeling the visa had been current. I have a feeling the visa. So back then, if you already had a visa, a B1, B2, or
Yeah,
B2,
it's
it's
good for
valid
you.
for 10 years. So he's just now, it's just photo sub.
But he said he ended up in O'Hare. So the question is, what country, what connecting country did he go? Because usually those fly into JFK. So or Newark. So the question is, he ended up in O'Hare. So if I'm taking a route from India, how did I end up in O'Hare of
I'll
all
ask him that.
airports? You see what I mean? It's
Yeah.
in the center. It doesn't make sense. Either you
It's
fly one way or
15.
the
So
other.
I'll try to figure that out if he
And yeah, so
remembers
be
anything.
careful about it, especially if you're going into these federal filings or you want to go on. Because if he's just an EV, he can just be an EV. But if he's saying he's got the
No,
B2, but if he's got
I
saying he's got
believe,
the B2, that and they don't have any record stuff of it, at least
no.
initially. Yeah.
I got to explain that one when you get to it, but go ahead and finish what you're saying.
No, so what I was saying about it is, I think that's what I found. Just not because I thought about it, just because I had cases like that and it worked. Is that sometimes you got these admission paroles. Neither side can find anything from it, but sometimes it's common sense. Like I had one from Trinidad and Tobago. I could prove she was with her brother in New York, and I said, "Come on, 1970s, Trinidad and Tobago, like." Did she like swim across? It doesn't make any sense. There's common
Right.
sense that dictates things. And I had to affirm under the penalty of perjury I'd never been to Canada, I'd never been to Mexico. How'd I end up in JFK? And I could prove she was in JFK. it's really recreating the flight routes. And I just think maybe that's a good thing that if anybody's listening, just a tip that I kind of just fell into was we don't really think about this, but in those tough cases, recreate the flight routes with the logbooks, and you can start putting a really legitimate because it's preponderance, right? Right? Is it preponderance, Rob? And I think
Yeah.
Yeah.
that at first you could show from a country that, hey, everything I'm saying kind of matches up because there's the flight route. I've seen that help.
That's a good one. I just put in a motion to terminate on the removal part of the case because I just came in on it and basically said he was pro se and any pleadings, if there were any, he never admitted to coming in illegally. And I want to, and I'm sidetracked on that one. I want to let you guys know what I've done in Charlotte that's working too. When they're sending out, this is just a thought. I'm going a different direction. I'm going to come back to this case, but I put in, I've been denying the allegations and the charges now, because if they want to play like this, it's their burden, let them prove it. And, they're scheduling orders out of Charlotte that if the government doesn't submit proof, within 60 days, then the judge welcomes a motion to terminate. I put in the motion to terminate and gotten 2 cases terminated.
I got one. They refused to terminate it, and that's exactly what happened. And they just refused. It's fine. The only thing I'd be careful about is when you do the denial of the first allegation, you put a qualifier saying we're not claiming any U.S. citizenship.
Yeah, well, I put basically no on that one. I just put no. What was the word? No admit. No.
I wouldn't even do that because it's claim. So what I do is because right now I have a denaturalization case. We just had.
Well, it's not. It's not. It's still you don't. As long as you're not denying. It doesn't really matter. Honestly, I know as long as you're not claiming to be a U.S. citizen, that's not a false claim to U.S. citizenship.
Correct. But
It's the government's burden. Don't want to put the burden on yourself. Like I was the government. When I had to prove things, make me prove it.
But I remember, Rob, didn't Cleveland take the position, OPLA, at one point? They were taking it that you do the general denials they were claiming as U.S. citizenship. And I think if anybody has a DNATS case there, I have an argument that's going up. Preserve the right that a denaturalization does not take away their U.S. national status. So you could say I accept that I'm not a U.S. citizen, but I will not accept that I'm not a U.S. national. This is an interesting argument that's actually going up there. We had a pre-hearing conference on it, that nationality has to be revoked in a different way. So it's interesting. Just
oh, that's true. Yeah.
Yeah, and they're defined very differently.
Yeah.
So
Okay, going back to that bond hearing though, because I want to just give a few points on that one. I love what you said, Honest. I did have him question in the bond hearing, and that's when the judge was the only thing she really seemed to care about was like, did he put in a T visa? Because she knew he was credible. The problem is I don't know that she knows immigration law, like to me, because the fact is the burden is on the government. Even in the bond, you want to hold her in and say she doesn't even have a right to a bond hearing. Prove to me why. He doesn't have a right to a bond hearing. So you're telling me he's iwi, but you're telling me that based on the I-213, which by the way, I got the judge to did not admit into evidence because they tried to serve one that was not signed. I had no opportunity to question the maker. I don't know that officer only had 47 days of training. What I do know is that officer lied in the document and put down that my client had been arrested for some aggravated domestic violence with a weapon, with some kind of a violent weapon, when all he had was he went to a custody hearing 9 years ago with his wife, and they verbally disagreed on custody, on visitation times, and there was nothing. He was never arrested for that. That they put that in there. So they didn't admit the I-213, and
that's a big victory just by itself.
yeah. And then she goes, but I'm going to rely on, I have to, she said, and I want to know what you guys think of this. I have to rely on the pleadings and the removability charge already found, which is on iwi. And I'm thinking, well, we're in the bond hearing. It's funny. She wants to go to the removability hearing when it's convenient for her. But when it's convenient for me, she doesn't want to go there.
I think this BIA precedent stuff says they can peek into the removal record, right? Isn't that right, Rob? I think
Wait, say that again.
in a bond hearing, I think that there's like BIA precedent or something that says an immigration judge can peek. Like if you wanted to submit evidence as a respondent, you got to submit in both. But I do think
Yeah.
that the IJ is permissible for them to peek into the removal record when making their bond
Okay.
determination.
But they're not bound by that.
They're not bound
Yeah.
there, but I think it's permissible, right?
She said the word bound by. I am bound by the pleadings. First of all, there weren't pleadings. And he never said he came in illegally. He's always said he came in,
But at the
and he
end
was pro se.
But I think what's really interesting, and I just would love if we could get really it's just been staying with me is you guys hear about this green cards totally revoked by Marco Rubio, detained by
Yeah.
ICE.
We were
Oh,
talking
yeah.
about that,
Yeah.
yeah.
I wonder what the removability charges and what's the basis for revocation. They must have not been able to rescind it based on the UCIS, right? But here's my argument: is there's no expat. If due process due process definitely applies to an LPR, I think, right? On his
Yeah.
right? I hope, right? So if you got that
Yeah.
due process, hey, isn't the Constitution prohibit expats, PAXO, whatever laws? Like you can't just pass something that's now and say, oh, you did it in the past. Now you're going to get in trouble for it, right? I think that's a constitutional principle. So
Well, and I just seen that thing just like a couple hours ago, and the interesting in reading the press release, Secretary Rubio indicates that they revoked the visa underlying the green card status. So I mean that's an interesting procedural issue.
it
I mean,
depends if
Secretary
you
of
have
State has
status or visa.
yeah. Well, the Secretary of State has a lot of discretion on revoking any kind of visa, but how that impacts the permanent residency is a separate matter. But I think most alarming in that press release was it talks about these people are detained now.
You know what's interesting? But here's the thing: is can they detain them? An LPR, per matter of law, you retain your LPR status until a final unappealable order is entered that removes your LPR. So
Yep.
are they trying to say there's security risk or something? Are they detaining him under criminal or something? But the problem is, it would all be. I just Rubio. I think he's trying to do the same thing they did with that other famous case of the Palestinian detainee. Is there's easier ways you guys could do it if you really want to use the power under the INA, but they're kind of fumbling it now and they're using it in such a way that it must be a security thing. I think they're going to use a security prong or something. But
Well, they said that she's like the niece of who is it, Rob?
She was like a niece of a general in the
the famous
some
general
Iranian army.
Qassam Soleimani. But I mean, like,
Yeah.
let's be honest here, okay? That I guarantee, if they knew that, I guarantee she properly disclosed it on her application of the LPR.
I knew it.
All right, she probably. Let's be honest here. She seems like she was living very fluently. They probably had the best immigration attorneys. They disclosed what they have to disclose, and somehow they got the LPR cards. Because I mean, if they've totally faked everything and there was no connection, then this is an easy case. So they'll just revoke it, fraud, and they'll get them out, right? But I'm thinking that it didn't. The press release would have said they fraudulently lied or something. No, they were aware of them. This is all there. So she has
No, the press release is saying it's the niece and her daughter, and a niece and her daughter doesn't qualify under the terrorist grounds. Only spouse and children, I think, right?
Exactly. Yeah.
So this relationship doesn't qualify. You can't make up a new law on that. And I don't know why they're talking about the immigrant. I guess she came in on an immigrant visa. So she came in under an immigrant visa.
She probably consular process, or they're mixing it with an adjustment of status. They don't know what they're doing.
Yeah, but once you come in and you're admitted, it's done. You're admitted as a lawful permanent resident. Now you are entitled to a removal hearing.
You can only lose it. She must be
in a
consular process if they're using the U.S. Department of State, and it must be beyond 5 years. Otherwise, they would have rescinded it based on the UCIS. So
yeah, they can't rescind it. They have to do a removal hearing, and they have a right to.
Yeah, but if they have a good counsel, if they put them in expedited removal, you ask for a hearing, then you can prove you meet one of the exceptions. She's a lawful permanent resident, right? Am I right, Rob?
They can't do lawful expedited removal because
unless it's criminal detention.
Right.
Well, yeah, but there's also the freedom of speech exception under 237. That's specifically written in there. Secretary of State has broad discretion to make a foreign policy determination, but ultimately it's going to come down to an immigration judge who will likely fear for his or her employment based on how he rules. But
Wait a minute, Rob. What did you mean 237 freedom of speech? Did you mean First Amendment?
yeah, there's built-in protection in
Yeah.
I don't think
for
she's even said anything. This is not even a protest case.
Well,
This is
they're
straight-
claiming.
yeah, the press release said something about some pro-Iranian stuff or whatever.
Which
You know,
what's wrong with being pro-Iranian? I mean, right now I'm pro-Iranian right now. Am I allowed to be? I'm not pro the bad things they do. I'm pro
the issue
human rights.
is if the Secretary of State makes a determination that she's done something that invokes the security or a compelling U.S. foreign policy interest, then he's got to make that determination to override the freedom of speech, the First Amendment exceptions.
But he's got to give her
the
fair
INA.
notice. He's got to give her fair notice. So he
Right.
would say now to them, listen, you guys can't do anything more because of your specific special situation, that if you take certain actions, we believe it would be a security threat, and you've been warned, and they continue doing it, then they can invoke that part of the INA, right? But my problem is they invoke the INA before any fair notice of what they did, like Muhammad Khalil, whatever. I mean, I think under the INA there could be a mechanism, because the strength of it is to really, to put him in different, removability situations. But it's all they use the actual thing of Marco Rubio giving an opinion. But Marco Rubio's got to give fair notice. There's no due process without fair notice, right?
Definitely.
Well,
But can I ask you guys? Can I give you a different hypothetical? What if this were Italy, or what if this were? I mean, What if this were Italian Americans back during World War II or something? Like, just because you say something positive about a country that your forefathers came from, how is that I just really want to know, how is that a national security risk? That means any one of us that says anything about a country that we've come from, we have no freedom of speech?
No, I think,
Well, yeah, I mean, we don't know what she said.
I think it's apolitical. I honestly think it has nothing to do with the actual politics or influence. I think it's a test of executive power. And I think what it really is, I think it's irrelevant. It may just be now these are the convenient things to pick on, but I don't even think they're thinking about the politics or belief or race. I think what they're more interested in is this mechanism that we use for the more difficult cases and more complex removals and detentions. Is this an easy way to do it under the INA, which by the face of it seems like it provides an ability of it, and now we have more conservative, maybe some conservative interpretations. The BIA is stacked, so the BIA will probably take a look at it. Immigration judges are not separate from the executive branch. It's be very difficult. They could get good BIA precedent and be able to utilize this provision for a while until it gets to the circuits in the Supreme Court. And Congress is not going to move to amend the statute. And the president controls the executive. He's not going to change the regs. So I think what it is, and I'm not even saying that it's being done in like a nefarious way or like an evil way. I just think
I'll say that.
I know, but I don't like to judge. I'm just looking at it in a mechanical attorney way. And what I'm looking at it is, I understand that there's a gray area in the way the statute is and right now you have a very strong executive. Okay. So I think now it's testing the limits. Because think about it. I mean, even with district courts, am I right that the district court judge can only make a limited injunction? He can't do a nationwide injunction anymore, right?
Correct.
You have a lot of things going through the judiciary that, again, this might be a quick way that it would be very hard to challenge, because even the Supreme Court might be deferent to foreign policy manuals to the executive. So I think they're trying to tie in the broad language in the INA and lump it into the executive's deferential treatment when it comes to foreign policy manuals.
But can't you? Let me be the bad guy then, because since I used to work for the government. But can't you guys all see how this is literally everything you're saying is exactly right? But can't you all see how this is a testing ground for the next steps when it comes to us,
100%.
to U.S. citizens? I mean, they don't want us to say anything against whatever it is they are for, whether it's a war in this country, that country, whether they're bombing a black neighborhood here one day, whatever it is they want to do, we can't say anything negative about it.
Correct, but
It's a testing ground for that.
But I think what it is analyzing the legal structure and the separation of powers and understanding where is the next ability. So, for instance, you have a situation where immigration judges, unfortunately, I think, I met a lot of immigration judges, and I was just saying to Rob, because you used to be one, you were great, they try to do their jobs. They're nice people, they're smart, they're on a lot of pressure, and I think they're great service to this country, but I understand if I'm in their situation. It's like sometimes you want to make a great decision, but you're like, yo, I kind of moved my family out. I could really use the benefits. I'm a judge. I can't do extra work on the side, so this is my only income, and I don't feel like being walked out. But at the same time, I swore something to the Constitution, and I'm a good moral person. But they're put in difficult situations because they're not a separate entity. Okay, so I think it has to go into some certain fixes. Like if there was a separation of the immigration judges outside of the EOIR, made them a little bit more independent with checks and balances, thing could happen is I think you have a lot of great minds that can help solve the problem legislatively through precedent and can help do both things, safeguards. Because listen, it was Congress's intent to allow the Secretary of State to make certain determinations for removability. That's Congress' intent. That's the law. We have to respect
Well,
that.
they never knew they were going to have someone that was in the Epstein files.
That's correct.
Yeah.
I mean, that's correct. But that was a passed law. That was a duly passed law that we are sworn to uphold. But the problem is, it's the interpretation of that law or the safeguards that are put in. Also, Congress or oversight or so on. But I think the concern I have is foreign policy is just an area that there's just so much precedent and law that is deferential to the executive branch and the commander in chief. And now you have a military action of the War Powers Act. So if I'm looking at this as an attorney, right, and I'm going into that case with the 2 green card holders that are General Soleimani's relatives, you have a situation where there's a operation under the War Powers Act that is saying that there was an imminent threat. You have Marco Rubio, the Secretary of State, issuing something, let's assume that has to do for national security, during a time like this, and they just happen to be, really close to the persons that assassinated, were assassinated by President Trump and so on.
Which is illegal.
It's hard from a legal perspective to have a judge or something really take a strong position the other way because they want to defer to foreign policy. So when we're looking at this, we got to look at the other mechanisms that would somehow rein in that power and get decisions like this for detention away from the foreign policy power, which
But here's the problem with that, Anas. Like everything that we say can't be a political, even in other countries, right? When it's a political crime, it can't be considered. It doesn't matter that it's our country and it's our president. When they're committing war crimes, they're committing war crimes. It is what it is. When you hear our own military saying that, and even the national security advisor, is that what his role was? Kent?
yeah.
That stepped down. I mean, when you hear that when we know that there are war crimes being committed and Congress is not actually, I have clients that their children are in the military. And of course they're saying what they're told to say, that we're not actually in war because Congress hasn't declared war. Well, but I have other clients that are getting orders to go over there. So, and boots on the ground. So we're in war. It's just it's not a legal war. And so what I'm saying is, is it illegal? What is the national security risk when we have a president that should actually be, I'm not afraid to say it, come after me. But it's a war. If there's war crimes being committed and there's a children's school, a girls' school that is being blown up, there's a problem. I think they have a right to say that that's wrong.
I'm with you, but
the underlying problem, though, that I'm skin to is Congress has already delegated all this authority, and with the judges coming under the Attorney General, all of that's already delegated by statute, and the situation now is such that in Congress has been broken for so long. There's no way that they can claw back any of that. The sides will never agree enough to pass any kind of legislation that'll claw back any of that authority from the executive branch. So I think Anas's point is correct, that this administration is being incredibly aggressive to try to find every little thing they can do under this sweeping authority that the INA has given them. And I don't think any administration in the past, for good or for bad, has been as aggressive as this one has in trying to suck up as much power as they can under the immigration stuff. And this is a good one, and a good example of that. And I think the next step will be denaturalization cases. I mean, if they can claw away some green cards from people and put them in detention, and they don't have to be, however many green card people there are in the country, they don't have to win 100% of the cases. They put enough people in detention and 10% just give up and go away.
Yep.
That's a huge victory to what their ultimate goal is in reducing an immigrant population.
Rob, I would love to hear your thing. I actually have a big DNATS case at a pre-settlement conference, which I had a deal.
I just wrote a book on that, by the way.
I know, seeing it. It's great. Everyone get it. So what happened in my DNATS cases, it was weird. I had one attorney that wanted to observe. I don't know, it's a WebEx. I was like, okay. Then I had another attorney advisor for the judge that wanted to be present. I think because they knew it was really complex.
Because this is the next step in the next. I started practicing about the same time you did, Susan. 96, 97, 98. Back then, from 97, when I was admitted to the bar, until about 2003, I don't know how many habeas cases I filed. I mean, just dozens and dozens and dozens. But between 2003 and 2000 and now, it was almost you almost never seen any habeas cases. I mean, it was really rare. You'd see the mandamus, and so all of a sudden there was this rush of people trying to learn how to do habeases and things like that, and that's going to. I think the next thing is going to be DNATS, because how many people do you know? I had a couple, 2 decades ago. How many people do you know that have handled a DNATS case? And so it'll be a slow uptake from the defense bar to figure out how to defend those and how to litigate those. And in the meantime,
they're very hard.
Well,
I was the government before on those, so.
Yeah. In my case, they did a million mistakes, and they're just trying to document my case so they don't do it again. So what they did was, under the denaturalization, and the reason why I know so much about it is I read Rob's book. You could civilly denaturalize. No statute of limitations. U.S. attorney initiates it. And if you civilly denaturalize, the statute says all your derivatives of beneficiaries, they automatically have their status revoked. So in our case, they decided to get a little cute. They waited 9 years and 9 months and 11 months and 29 days and filed right before the 10-year statute of limitations criminal denaturalization. And I was loving it because I said, listen, you got no priors or nothing. You're going to get probation, right? So he loses his case, even though I thought he had a good case, and loses his appeal. They criminally denaturalized him, but guess where the mistake was? He happened to have a daughter when he was a United States citizen that acquired U.S. citizenship by birth. So what happened was I was very happy, but I knew that I needed to get him into removal proceedings. There was a proceeding where inside the federal court you could have asked for the relief or whatever, but I just didn't want to mess with that. So then I had him apply for an LPR card, and it's still a gray area if they're an LPR or not. Everyone just assumes that they're an LPR. Me personally, though, I look at the statute, I think they're still a U.S. national because they never gave up they still have an allegiance to the country because it's defined in the statute that you have allegiance to the country. All the case law only deals with people that had pending naturalization applications, people that swore took it before they swore the oath or got their national. But there's never been a case where someone has been denaturalized after 10 years. And there's an actual portion of the code that says how you revoke your nationalization. Whereas,
how is that? Because that's interesting.
Usually
the
nationality. You're a consular officer and you have to revoke your nationality because the regulation is defined as having allegiance to the United States. So when I take a naturalization, yeah, I might have acquired it falsely, but my allegiance wasn't a false. I really did allegiance to the United States, even if I procured it naturally. So what happens is I deny that, and I, even though they say it, they were trying to get me into saying it's just not possible. I said, yeah, it might not be, it's not logical, but I don't care what's logical. I care about the statute. Again, it doesn't say anything about. So what they tried to do with me the day before
That
the
is
settlement
smart.
conference is
I
they
love
took
it.
the denaturalization provision, which it wasn't even fraud. He was actually honest about it. So they just said procured unlawfully, and they tried to use two criminal cases that were done on him to revoke his citizenship as CMITs. And I just pointed out to the judge, and I could have got them in trouble because you're at a settlement conference. You got to have settlement authority. You got to be prepared. You can't say I don't know, right? And I said, what are you talking about? There's been a case since 1964, I think, or 67, Costello, which specifically says even if I take away your naturalization, void abitino, we're not. I cannot use crimes that were acquired when you were a U.S. citizen against you for
Yep,
removability purposes. There's no relation
exactly.
back. And the Sixth Circuit affirmed this recently. They said there's no relation back. When you were a citizen, you're a citizen. So whatever it is there, you can't use it. So what
Yep.
they're really concerned about this
And
case where they're trying to throw that on
the
there.
government knows that. They've been, because
Yeah,
I
so
knew
they
that
wanted
way
to just see
back.
if I knew my stuff. That's all. So
Yeah.
it's going to be an interesting one. Now I have to replead. And I offered them an opportunity. I was like, Your Honor, instead of them, doing this, just withdraw it. I mean, the problem is they don't need it. Okay? But the problem is I'm keeping that nationality argument because I have not found a case where they decided on the issue of somebody who's a 10-year citizen. Usually it's, pending applications. And this argument's been, really presented forward. And we're in the Second Circuit. So it's interesting. But what I told everyone was this, and I don't know why the government just doesn't take this on. I said, listen, and I won't talk so much about it, sorry, but I said, just give us a 237A1H waiver. You guys made a mistake by the criminal naturalization. He still has a qualifying relative. I don't have to show hardship. He has no problems. They're like, well, you could apply for cancellation of removal. I said, no, it doesn't matter. If I don't get discretion for a 237A1H waiver, I'm not going to get discretion and prove extreme hardship for cancellation. So now the
Right.
judge is actually big on it. Because she doesn't want to deal with the nationality argument. So,
Oh yeah, because that, you know what? It has
It's
never been argued to my knowledge, because the only thing we ever taught at the academy about a U.S. national is that, person born in American Samoa.
but I read Rob's book,
Oh, thanks, Rob.
and I just doesn't a plug out there to everyone. Read Rob's book, and then you'll sound like me. We go down the rabbit hole.
Well, but in that case, though, if you retain his national status,
He can renaturalize.
yeah, well, you wouldn't have to readjust.
No. He doesn't. He just
He's-
renaturalizes. He's a national. He can
He's
renaturalize.
got to work on.
And
Yeah,
here's the thing about it, though.
He
He decided to
authorization.
vote. So after it's done, his attorney didn't tell him not to vote. He votes.
Uh,
But guess what? He only voted in a state election. Okay?
Uh-huh.
And I have proof it was a
Yes.
state ballot. And I have proof in New York that if you accidentally do it, then you are immune from the crime. And the federal statute says if you're immune from the state crime, then it doesn't count against you as long as it's not a federal election. But I mean, look at the stuff I have to
Wow.
prove for this guy. I mean, it's like he's a really lucky
Jeez.
guy that I somehow read Rob's book and knew how to defend him.
Yeah,
well, and
I got to get your book, Rob.
you were, and based on the fact that they chose to do it under the criminal grounds,
Big
they were
mistake.
probably, yeah, well, and they were probably rushing to do that because they seen the
Yep.
clock ticking. So they
There's
made.
no clock for civil naturalization. There's no clock for
That's
it.
what I'm saying, though. They were focused on the criminal, so they made the
They
double
wanted
mistake.
They wanted that stat. They wanted that stat.
It was.
Yeah.
I mean, like, I don't even know if he won on that criminal. They probably could still bring it civilly, but it might be res judicata. I don't even know. They probably not because the res judicata they would
No,
say
no, no.
yeah,
You have
criminally.
to pick. You have to pick one or the other.
I mean, no. If you won criminally, they might just say you didn't commit the crime. But under the civil thing, it's different. It's not the same issue. It's a different burden of proof. So, I mean, if he actually losing his criminal case might have actually been the best thing to happen to him. Because again, if he loses it, they bring a civil denaturalization, they win. His daughter loses derivative status, no 237A1H.
Yeah.
She's getting all the, and I'll be honest with you, I don't want to win on the national argument. I don't want to win on all the other technicalities I found in the allegations. but I'm stuck because I have to defend it. But if I win and I get this terminated, it is the worst thing for my client. Why? Now he has unclear status. Basically, they can never bring the removability charge against him again, but he can never get a waiver of 237 either. He'll never be able to naturalize again. He's stuck in limbo status. Would I be right, Rob? If I
Wait,
dismiss,
He won't be able to naturalize again because of the convictions.
he won't be able to naturalize again he because his green card was acquired unlawfully. So they take the position that he was never properly admitted. Now, if he applies again and tells all the truth, they'll
Oh,
deny him, but they just can't put him in unless he lies again. They can't put him
Yeah.
back into removal proceedings because he's already won it and it's res judicata. It's done with prejudice.
Yeah.
That means the only way you can get a 237A1H waiver is in immigration court. So I'm
Yeah.
stuck here because when people want to run and dismiss cases, but be like, wait a second, have that discussion with your client because he'll be stuck forever. He wins 237A1H.
wait, I think that's what happened to my client. Now I'm thinking about it. You're saying a 237A18, you can only get it in immigration court. So the I-601, once they terminate,
You don't need an I-601.
I'm
237A1H
talking
waiver
about,
waives multiple frauds. You're,
okay, so when you do, yeah, that's right. Okay. But what do you put it on? What do your judges make you put it on? Like
I
the
don't put it on
waiver?
anything. Actually, sometimes they don't even make me take the biometrics. I do not put it on I-601. I literally just submit like a brief
The brief report.
brief
Yeah.
with some supporting evidence. I say 237A1H waiver. And then one time they tried to say that I missed the biometrics requirement. I said, no, you never provided me the proper instructions for an for 237A1H waiver. And by statute, you guys violated that. So
They're,
if you're
I
ever
don't think
stuck
they're
on it, just say you never
required.
provided
I
the
don't think
instructions.
they try to
Yeah,
do that to me too. They're not required though, right?
Yes, they are. They're required to provide us 237A1H waiver
No, I'm
instructions.
saying I don't think you have to do biometrics unless they make you do.
I think technically you are under the Real ID Act. But if they just waive it, I mean, it's on. But everyone does biometrics. If you're detained, you did biometrics. So
Well, if you're detained, but they already have them. They can just rerun
biometrics, yeah.
them.
I mean, you can submit to biometrics, no problem. But I think with a 237A1H waiver, again, it's just a discretionary decision. But the problem is, even the judges are taking a little strict on it. But think about it: a 237A1H waiver, no hardship finding, qualifying relative,
Yep.
boom, you go to discretion, right? Oh, and it's got to be within admission, but it's usually it's clear. Okay, if it's meant for willful and non-willful misrepresentations. So that means by adding both, it means that even if I intentionally lied, I should still qualify for the waiver, right? So the problem we have is the judges shouldn't be able to use the fact that I was just intentionally lying solely as a determinative factor to deny my 237A1H waiver. Otherwise, if that was the
Yeah.
sole reason for doing so, then you basically made the statute useless because it would have just said not willful crimes, right? So
Right.
there's a layer of factors that you really got to lay it out there. So it's got to be like willful plus, like I robbed a million people. That's how I look at it for a 237A1H waiver. So I'm straightforward with the judges. I'm like, let's not waste all this time. If I cannot win a 237A1H waiver, I'm not getting any relief at all. So what's the point?
True.
So I skip everything and go right to the waiver.
Yeah, if they're making that level of argument, yeah.
Where are you at with that case right now?
We just had our pre-hearing settlement conference. That was supposed to be for a decision on 237A1H waiver, but then I got a new assistant counsel that jumped in. She was totally not prepared. She submitted, just a simple mistake. I mean, I put it on the record. It actually made them look bad, and the judge started coming on my side because she's like, "Come on!" I mean, like everyone knows about the Costello case. It's like, what are you guys doing? It's the I-261, and I even offered them the opportunity nicely, just withdraw it. Don't make me put it in there because I know you have an I-261. You do it any time. So anyway, I mean, we're just going there. I got to do amended pleadings. Then we're briefing the issue. The issue is very easily briefed. U.S. Supreme Court, right? Then we're getting into.
So you're in front of an immigration judge.
I
The
am.
district court.
The only
The district court part's done.
Yeah, but you know what? I will commend the Buffalo Immigration Court. They're very good judges. They're very nice people.
You
They're
love
good.
them.
They're fair. They're really good. They do a great job. They're very courteous. OPLA up there does a great job too in Buffalo. They do a very good job. Everyone's very professional. I can't say nothing but the best things for them. And I'm very privileged that I get to deal with that area up there. I think totally my favorite spot ever. They're fair, and there are a lot of smart people there too.
How long after the criminal DNATS proceeding did they issue the NTA?
Well, I had to apply for a green card in order for them to do so. But I advised my client. I told him, "Hey, dude, you're taking the risk, but I'm telling you that's what you got to do. Otherwise, he would have just got picked up and detained, right?" Instead, they NTA'd him before they had the mandatory detention policies and everything, and no big deal. He's got NTA'd, and he can use his receipt notice for his LPR as proof of his LPR status. It was extended, so I don't care what they do. I mean, I have someone that had criminal charges, right? That made her that they required. I mean, they were not aggravated felonies, but they were controlled substance offenses. Under Biden, I was able to reopen it, dismiss it, get her green card while she was still removable. But she had an unlawful claim to U.S. citizenship issue that I just thought was a little risky.
Well, but that was kind of what I was curious about. After the denaturalization process, were they trying to say that he had no work authorization, or that he was not removable or anything? Yeah,
Rob, I'll be honest with you, Rob. Everyone just assumes that you return to a green card holder, but there's no statute that I saw, no case law, nothing that ever says you actually return to an LPR.
You're right. The government just assumes that. That's the way they taught us.
Exactly. I mean, if I was I don't know if I should say this, but I might as well say it. If I was the government, I would assume they're iwi.
No, they don't lose their. Well, that's interesting, but I don't know.
Because they're unlawful from the beginning. I would assume they're unlawful from the beginning.
But they have to get the lawful permanent resident status to get to the citizenship.
Unless they never had it to begin with.
Well,
it's interesting. Yeah. I don't know. I mean, I'm glad I'm not making that decision.
But you can't take away the green card without going through a removal hearing.
But what says when you're denaturalized that you return to a LPR? It's just assumed.
Because it's assumed because they're not taking that away in district court.
But once you turn into a citizen, your LPR status is evaporated. It's gone forever. So how can you return back to it? It's weird.
Well, that's not the way we were taught.
If anything, my argument is you remain a
and they would put them in removal proceedings. What's that?
My argument is you have no other status than a U.S. national.
Well, national has a lot of status, actually. That's a pretty good status.
It's a great status. But that's the argument because once I become a citizen, everything's gone. So if you take it away from me, I still have my allegiance to the United States. It's not fair. Regardless of what you did, I took an allegiance to the United States in my nationality. So the only way I can revoke is I have to go in front of a consular officer as per the regs and stuff. Because it says revoke citizenship. It does not say revoke nationality. It says revoke your citizenship.
Most countries, I didn't know this, but like, for example, like when Indians become Canadians, it automatically revokes their nationality.
Yeah. But we have a statute on revoke nationality. Just nobody's ever read it. So again, the statute's worded wrong. It says I revoke your citizenship. It does not say revoke your nationality.
But what's interesting is when people become citizens of this country, we don't realize that because of the statutes of other countries, they automatically become nationals of this country as well because of the allegiance, but also because their country no longer recognizes them as nationals.
So now the judge is making the argument that I only got my nationality because of citizenship. So because my citizenship is gone, my nationality should be gone. But I said the Supreme Court thinks otherwise. If I commit a crime on a false citizenship, you can't use it against me when you take away the citizenship. So if I got my nationality on a false citizenship, there's no relation back to take it away from me if I lose that citizenship. That's the same analogy, right? Mm-hmm. It's the same analogy. If I cannot use a crime against me when I'm a citizen, you can't use my false citizenship to take away my nationality. You can't revoke because look, it never said in the Costello case you return back to an LPR. It just said you cannot use it against you to be removable. So it could be, so again, if I cannot use my actions in that fraudulent thing to take away my whatever status I have, then if I'm a national, it makes perfect sense.
You're absolutely right. I don't think anyone's ever brought this up. I mean, you took an oath, you become a national.
I mean, look at the rag. They try to interpret different ways, but it
You
says
become a national and they're not properly taking away the nationality, and you said there's a statute for that. So if they're not taking away the nationality, you are a U.S. national.
I mean, you cannot make an act superficious. So what do we have a whole thing in our INA saying how to revoke nationality? Why do we need that if you're automatically revoked? Why does it only say revoke citizenship? I don't even think it says all privileges thereof. I don't even know.
The thing is too, on that NTA that you got
May
issued
or not,
for
but
your
I still don't
client,
think it applies to nationality. I'm sorry, go ahead.
on the NTA that you had issued for your client, they have the nationality wrong then. Because
Yeah, and that's
your
what I
client-
did. I said I deny I'm a U.S. citizen, even though I don't think they did all the formalities. So if they made a mistake and I'm still a U.S. citizen, it's not my fault. I'm not claiming it. But I deny I'm not a U.S. national. Because if I argue that I'm a U.S. national, the false claim to U.S. citizenship doesn't apply.
Right.
So I don't lose anything from it. So
Right.
I'm keeping the nationality because my argument is there is no green card to go back to. There is nothing to
can't
go back to.
remove-
I became a citizen. I still have my allegiance. You cannot take away my allegiance. In allegiance, you cannot fake it. I mean, I actually have allegiance.
But not only that, you cannot remove a U.S. national unless you get rid of the nationality.
No, it's a termination, isn't it? And so I might actually even try to terminate before I go to the 237A1H waiver and just say he's a national.
That's a termination. I mean,
But
if that doesn't put that puts him in a legal limbo. I thought you said.
No, but not if he's determined to be a U.S. national.
Well, he is a U.S.
That's
national.
that's better than a green card holder.
So I would move to terminate based on the fact that he's a U.S. national. And U.S. nationals
Yeah,
cannot
he's
be
a national. He could naturalize. He's not removable. He has automatic work off. I mean, he can get a passport.
Yeah.
So what my
You cannot be denied admission, or U.S. nationals and U.S. citizens do not need to be inspected or admitted either.
So
You
I
can
might
go in and out.
make the argument because she argued though. She's like, if that's the case, it's like, yo, you know how many people will be doing it? And I told her, I was like, Your Honor, yeah, I know exactly the repercussions and everything's for, but my job is to follow the law and apply the law as it is written based on the precedent in the case law. So we shouldn't think about what politics thing. And I'm not saying that the judge was doing that or anything, but I was like, it doesn't matter if it would have a profound effect. If the law was written a certain way and we're following it wrong, okay, it doesn't matter the numbers of whatnot. We got to follow it right, one way or the other.
Yeah, I mean, it goes to the same thing as seeking admission. If they think seeking admission is anyone who entered the United States illegally, and for 30 years we've been doing it wrong, if that's what they say, right? 30 years, then yeah, there's millions of cases now of people out there that could probably reopen their removal proceedings because they were this is a possibility. They were denied that they were paroled into the United States, and then they couldn't do adjustment of status. There's other ways that potential, but the fact is they're using that right now and saying there was 30 years of doing that wrong, so we can lock everyone up. Well, the same thing with the U.S. national. Same thing with the U.S. national. If we're doing it wrong, then the person's still a U.S. national. They're still a U.S. national.
And you know what? If anyone gets mad about it, I say, you know what the simple solution is? Tell Congress to get together, fix everything, make it clear, and do it. The same way everyone else is using things. We're lawyers. We didn't create this language. We didn't create this framework. We didn't create these cases. So we got to do what's best we got to do so we can put it together. But maybe something big like this would be enough for everyone to wake up and be like, okay, why don't we just make this simple? Let's fix it for the people that should be here. Let's fix it. Maybe there's citizenship, maybe there's employment authorization, whatever it is. Get together. It's not even a political thing. It's just a thing of let's just fix it, make this simple, make everyone's job easier, and we figure out what we're going to do. We might as well make it in a law than fight about it in the courts. Think about how much money and time and waste we do in all these courts. Congress can get together tomorrow and just put it together and sign it for the presidency and just have like a streamlined immigration services and just make it compromise.
Yeah, and if that's what they want, if this Congress and this president, if they can get together and if that's what they want with regard to the term they want to change it with seeking admission means, like anyone who came in illegally. I mean, if that's what they want to do, I think they need to, codify it, like make it, clear it up, and
nothing
fix
will
it.
happen unless President Trump, Stephen Miller, everybody who I respect, they need to read Rob's book and his pro se immigration. I'm not even joking. He lays it out there perfectly. At least read that as a basis before you even start thinking things. And I'm really serious. I take a look. It is a great series. So I really recommend anyone doing it. Go ahead and take a look at it. Like when I read it, I was very impressed.
Yeah. Rob, you're the new Kurz bands.
Yeah, yeah. Except we don't charge $800 a book. So,
Well, you know, supply and
whatever they are
demand.
now. Last time I seen
As long as you're not charging in yuan.
them. Yeah. Yes. The it's an interesting question though about the as a national, because really in immigration court, do you even want to go down the 237 waiver rabbit hole? Do you just want to not seek termination there?
I like termination.
The problem is there's no judge that will ever give you a termination as a U.S. national. That has to
But
go
it's
to
your
the BIA
They have
and the
to.
circuit. That will go to the
it's
BIA and the
it's
second circuit.
the circuit court though.
I mean, if I have to, I'll do it just to get a denial,
But I
so
think
I
you
have a
gotta,
right to appeal.
well, yeah, I think you got to preserve the issue. I mean, I
Oh
think
no,
you
no,
got
I
to.
definitely got to preserve the issue. I did,
Yeah.
but let's be honest. But here's the thing: is I don't want to put that judge in a position yet to make a decision on the national. What I'm trying to leverage is, look, let's save all of our time. Obviously, I know what I'm talking about. I was lucky. I read Rob's book. I know what I'm doing. So don't make me go down that rabbit hole. Don't make me go through all these freaking analyses. You government, you're not ready for this. You don't have time for this. The guy has no problems. He has a qualifying relative. Hardship doesn't have to be proven. It's all clear. She acquired citizenship. And really, the guy didn't do anything. You didn't charge him with misrep. The guy came in as an uncle. I mean, his uncle told him when he was young that he was his dad, and he didn't even know. And when he showed up to the government, he told him, yeah, that was my uncle. I will never lie to you guys. And you guys did all this stuff to him, and he's never lied. And he has no problems. So it wasn't even willful fraud. So
Not that it really matters, but what prompted the denaturalization proceeding?
Yeah. What
because
happened?
his other kids' applications were not going fast enough, so he showed up and they're like, "Can we put you under oath?" He's like, "Yeah, sure." And he's like, well, "All this." He's like, "Listen, I'm an honest guy. I don't know what the immigration laws are. My uncle came. I thought it was. He's like my legal dad. Yeah, so I thought he could sponsor me. I don't know." And he told them everything, and they used his own words against him, and that's
Was he a
why
minor?
huh?
Was he a minor at the time when he sponsored him?
No. He just turned 22. And my argument was, but the criminal defense attorney didn't really, I thought, missed it. I was like, yo, we live in New York. He came to New York. There's a presumption of legitimacy. So it doesn't matter what the blood relation or everything is. His uncle represented, who was in New York, was married to his mother, and
Oh,
they claimed him
wow.
as a child of the marriage. They're both deceased now. They're gone. There's a presumption of marriage in New York. So it doesn't matter what he says. Even
Wait a
if he
minute.
says that's not my dad or mom, that's
That
irrelevant.
was the mom, though? Was that the mom?
No.
Was the uncle married to the mom?
No. But he was claimed to be his uncle and his aunt. So his uncle and his uncle's wife.
Okay.
So he was
Okay.
claimed to be a child of wedlock. And the person was in New York jurisdiction, and he passed
Yeah.
away. And he is, it doesn't matter if he says that's not my dad. Under New York, there's a presumption of legitimacy that he's
Okay,
presumed
yeah.
to be legitimate until he can prove otherwise, and his statements alone do not prove it. So he's supposed to be presumed to be legitimate. But again, I think
Right.
the sad thing is, I've encountered so many times, is no matter how many times you make arguments, it's unfortunate, but people just, I don't know how to explain it. You know what
No,
I'm talking
no,
about, right?
I saw it.
When
I
you
saw
come up
it.
and- you know when you come up and it looks so clear, but when you say it, just because it doesn't follow the logic or the traditional way, that people will just automatically reject it. And that's
Well,
how
and I
these
think,
things are made like this.
I think it's because there's too many eyes on them right now, because I think the logic, that's what I think shocked me on Friday, is like, I'm telling you, just take 10 minutes, government. It's going to be a lot better than a potential lawsuit if when I find this record later, because you're holding him illegally detained, he can't have a bond hearing. They don't take even the 10 minutes to go do the search, because
They got a lot
apparently
of
they don't even know how to do it. But again, it's a logical argument. It's rolling over because they're compartmentalizing, because they're just trying to get through the day. Like you said,
Yeah.
they're trying to get through it. You've probably been there, you ever had, well, back then you probably didn't have so much pressure, but
Well, but we would do those those Remain in Mexico cases, and I was talking to someone the other day. I mean, there'd be 350 people there for initial appearance at a master calendar.
So did you have to learn to just like not, I don't want to say the word not care, but compartmentalize so that you could just get through it? What you were told to do?
No, it really came to, because I don't feel like I was ever told what to do
Back then. Yeah.
At that time. And I think we were told that you have this number of cases, or you have this these kind of things need to be resolved.
Complete your
But
goals?
yeah, but I don't in like the Remain in Mexico cases. I mean, it was just a large volume, but there was a process, and you work through them. But I don't recall ever feeling like something had been dictated to me. Now you get the occasional an attorney general opinion would come down from BIA or something, and you're like, well, that's the law now. But I always felt like I was still independent enough to interpret that decision as I saw fit, and until such time as there was something more clear.
But what about now? What if Anna, like under the pressure they're under now, and Anna's comes or I come with a very logical argument that, I mean,
Well, and that and he almost kind of hinted at it earlier. By the time you get appointed an immigration judge, you're probably going to be in your 40s at least. You're going to be mid-career, and depending on how you got to that position, you're not everyone is financially stable and has the wherewithal to be able to say, "Hey, I'm gonna put my job on the line to make this independent decision." And I think that
No, I don't blame them. I
it's a
understand.
consideration. Yeah, I think a lot of
see,
people
I
have.
do now. I do blame them because I've been, and here's the reason why. Because I wouldn't blame them a few years ago. I've become a different person. And I think knowing that they are attorneys and they have ethical obligations. So it's not just a job that they're trying to keep. But to me, okay, bear with me for a second, is that I've been thinking about this a lot. And what's really bothering me, I think this is what bothered me the most on Friday too, is to see the system really go into what I believe is a form of fascism. And that's because you do have somebody who can tell you whether you agree with what Trump is saying or not, right? You have somebody who can tell you what to do and say, if you don't do it, I'll fire you. There's no judicial independence.
No.
And then you have the assistant chief counsels going along with it all. And for me, I couldn't do it. I do blame them because they took an oath to the Constitution. And I get the money part, but I've been there. I had a stable paycheck. It was a good paycheck. I had health benefits, but at the end of the day, I can go outside and I can get the source from the sun. And to be honest with you, I would rather know that I'm helping people have due process, and I'm not selling a democracy down the road that one day is going to come back to. It's going to come after all of us because their due process rights are being affected now. It's us next. So I do blame them because they could all, this is my opinion, they could all stick together and all allow him to go after all of them at once, and he can't do it.
No, I mean,
He can. Oh,
no,
but he can, but the American people have had it. What I mean by that is we're entering a new phase. I really do believe, and I do believe the energy is coming to good versus evil. I just believe this, and I do believe that that you have to stand up now.
no, but I
You
think
have to stand up.
I think I don't know. Even if I'm a minority view, so I just think that OPLA, EOR, the judges, and a lot of them are the same people we dealt with over across two administrations. I think they're doing the best job they can. I don't think they've been crossing ethical lines. Making tough decisions doesn't mean it doesn't mean that if I didn't make the tough decision that might be right, that it's necessarily unethical, right? It could just be.
You have good judges.
But but but
I've seen.
what I would say is, if you want to look at it the other way, under the Biden administration, I'm sure that it was a lot of people in government were like, wait a second, what do you mean prosecutorial discretion, dismissing cases like it's nothing, nonstop, and they still went along with it. They followed the chain of command, which they should do. It wasn't an unethical thing, but I'm sure that there's some people that could argue that that inherent prosecutorial discretion on a mass level and dismissing all these cases was not maybe what the INA was intended to do. And it's
I
a
agree.
great question. And I think they followed it and they were cool about it and they followed the direction of the president. So I think that, elections and who's your commander in chief, that chooses the attorney general, that chooses the heads of the immigration agencies, I think that's where the aspects. And I really think that the people at UIR and all stuff, they're good people and they do what they got to do. And I don't know, maybe there's a part of me that is, I don't want them to kind of like take it upon themselves to decide this is politically right or wrong because, again, when it was beneficial to removal defense, I was glad that they followed what their commander and what the president executive said and said to dismiss the cases. It helped us a lot, right, Rob? How many times have we
Oh
need
yeah, yeah,
so, but
yeah.
the same way it could happen this way, and I just feel like it's something that it's not really ICE and EOIR and the UCIS that can really deal with it more than it's more at a higher level. Where I understand where your frustration if these coming suits are from. It's totally valid. I respect all of it. I'm just an apolitical guy, but I just look at it as
I'm not
maybe
trying to be.
you're pointing at the wrong. Because check this out: a new attorney general. You saw how big a new attorney general does when you had Sessions, and then you had certain, and then when you had Garlick, that would just issue an attorney general opinion and change all the course of the BIA precedent. So really,
Look,
if you're looking at big changes,
I worked under five administration, so I'm not trying to be political. I'm thinking that immigration, despite the fact that it does go underneath the president's powers, I still think the courts though. And once the laws have been set by Congress, I think that the courts need to be apolitical. Apolitical. Okay. I think that the problem is that it's in the executive branch, and I think it should be in the judicial branch. And I think because once Congress codifies the laws, the president is yes, he has control over immigration in a broad sense, but I think the courts have to adhere to the laws. The laws are written by Congress. And I think the problem is every time there is a new administration, because I worked in the government, our heads would swing from one way to another. And the problem is, yeah, I could tell you there are things I did not agree with Obama, and there's things I didn't agree with Biden.
yeah, but I think
We weren't enforcing all the laws, and I just want there to be consistency, and I just want it to be fair and due process. That's what I'm asking
I
for.
think the way you do is because you're never going to get Congress to pass a law to separate the judiciary.
Yeah.
I think it's simple. It's contractual. Just put in their contract. Unless you commit like a crime and it's for cause, you're free to just do what you got to do and put a nice, good contract. Maybe isn't there federal unions? I don't know if there are or not, but
They decertified the judges union.
I think that's a problem. Well, if you don't want a union, though, at least do something where you give these people, these great practitioners that decide to go through a lot, to go through the background checks, do everything, to not have side hustle, put over lightweight, to sacrifice for our country. Give them a contract. It's simple. You don't. I don't know. You don't need a statute first for a contract, right, Rob?
Well,
They give
but
you a contract.
the administration would have to do it.
Yeah,
And
a standard contract saying
What do
that
you mean by a
basically about 5 or
contract?
10
You mean
years.
basically to protect them so that they can make judicial independent decisions?
Absolutely. And then but from a contractual possession, if the judge decides you want to go, that's fine. You pay me out on the rest of my contract. So if you're going to appoint somebody for a 5 or 10 year period, or if there's a probationary period of like terms, like we'll try you out for 2 years, you're great, we'll give you 5 years. If you're great, we'll give you 10, whatever it is. But if you're not terminated without cause, then at least that judge will be paid in full for the rest of his contract without an offset.
Well, I like that.
Because the
I like
contract,
that.
listen, from a perspective of the administration, I'm never going to give up my, total right to ever fire somebody. But at least it should be that, listen, I can only fire you for cause. If I don't fire you for cause, whatever's left on your contract, you'll get paid out in full. Then you get into a business decision a little bit that people will take a look at. So it's got to be something really serious if you're gonna take out a judge,
I like
because
that.
if you're gonna take out judges en masse and they're getting insane amounts of benefits, there's a budget line there, isn't there? And I think that
Well,
should
they
be
don't care
fair.
about that. They're not paying taxes.
But
Yeah, but
the thing is, at least the judge will get his compensation for the time he should have spent without offset, and it should be tax free.
No, that's good. I still love civil service the way they used to be. Those old school people that were civil service, I really feel, because I still think you're going to end up having a duty to the certain administration that's in power if you're under a contract. And I just think you need to be apolitical. I did my job. It didn't matter who the president was. I just tried to follow the laws.
But the problem, I think, the issue with that is Congress made immigration a political issue when they put all this into the executive branch. I mean, that's the history of it is Congress made it political. Now, the fact that the political swings are getting bigger and bigger, but that's across the board. I mean, in not just in law, but in other aspects. I mean, we're not that far removed from COVID, where doctors and lawyers that didn't agree with various aspects of COVID were being sanctioned by the bar or AMA or different boards. So it's the bigger swings are just something that's occurring, and
But
the root
why?
cause of that. Well,
The root cause is fear, right?
no, the root cause of that is that Congress 30 years ago gave all this, more than 30 years ago,
Yeah.
when the INA was with 1950 something, right? Gave all this authority to the executive branch, and the natural entropy of anything is that it's just going to get crazier and crazier, and that's going to continue until it collapses upon itself, either you know all the way to the right or all the way to the left, and then it gets rebuilt.
From my recollection, there's only one president that had the chance, that had a supermajority in the Senate, a congressional majority, and the executive branch, which is very hard to do because they cannot do it through budget reconciliation because because they tried that, and the parliamentarians said no immigration in the budget reconciliation program. So that means you need 60 votes in the Senate, and they're not going to nuke the filibuster for it. So there was only one opportunity. I think it was the beginning of the Obama administration, but I'm not blaming nobody. I know it's hard, but that was the only time that there was ever a 60
Yep.
vote supermajority that could have actually made a difference. And the
Well,
other time,
yeah, and remember there was it was like 06, 07, during the Bush administration, there was Ted Kennedy and I think it was like Ted Kennedy and Lindsey
That was
Graham had
that was
put
close
together
to
an
going
immigration
through.
bill. Remember that?
But people
yeah,
were
I mean,
still
there was a gang of
afraid.
12 with Marco Secretary Rubio, who was very hardline, but he wasn't, he was reasonable. But again, it just goes. And honestly, Rob, what's the weird thing about it is it's not that complicated. You fix the extreme hardship standard for cancellation removal. You get rid of the I-601 provisional waivers. You allow them to adjust like a new what Clinton did under the. Remember, he did the I-45Is or whatever. Where he allowed
245
everyone to say after a certain. It's not even amnesty. It's just saying you have a U.S. citizen approved I-130. We don't need you to go back home. We'll just adjust your status. Okay.
Yeah, that was Bush his first term. 245I sunsetted then back in April.
Yeah, I know.
30th.
Or adjust his registry, or people don't even either at least give people something. I mean,
Yeah,
there's
well,
small tweaks in our system that can really
yeah,
get rid of a lot
Well,
of the problem.
suspension of
Get rid of the
deportation.
permanent bar.
Well, yeah, it always comes down to that it's all or nothing. It's amnesty completely, and they become citizens, or nothing. And there's a lot of statuses in between. I mean, you can grant withholding of removal, which requires you to stipulate to removal first, and then you get the withholding. And if you screw up again, you're out the door.
It's perfect.
Um,
You do deferred action. You can
Yeah, deferred action is
get people
kind of the
in
same.
place and see what you're going to do. Me personally, I don't like to give my personal opinion, but I say I totally understand the argument that we can't just give everybody citizenship from the beginning. No, and there might not be a passage, but at least for now,
okay, if we're not have the ability to remove them or anything, give them a little bit of work permit, defer action for a little bit for people, kind of figure out what we're going to do, plan, and decide how we're going to process it. Of course, if
And
somebody
that's
committed a
something.
crime, get them out right away. But I'm saying for a lot of people, we don't know what to do with. Like, I feel like sending them to detention is not a problem. You put them to the system, give them a work permit, monitor them. I don't know. I mean, I just
Yeah, detention's ridiculous.
detention is expensive, isn't it?
We're
Yeah.
paying for that
Well,
like
yeah.
what, $200 a night, and instead they could be out working and putting into Social Security and Medicare, and instead they're putting them into detention, and they're making their families actually potentially a public charge, U.S. citizens. So they're U.S. citizen children.
Guys, oh, guys, forgive me. I might have to run.
Well,
Yeah.
no, I was just getting ready to say it's Saturday night. I'm sure you guys have things to get
Yeah.
to.
Well, yeah.
Easter baskets to pack up.
Happy Easter,
Saturday.
everyone.
Happy Easter.
Yeah. So, all right.
All right,
Good seeing you guys.
Nice to see you.
Yeah.
Good seeing you guys. Thank you for everything. I mean, good conversation.
Goodbye.
Take care. See you.
Take care. Bye.